Good afternoon, and welcome to the Employer Link webinar series presented by McAfee & Taft. My name is Brad Neese, Managing Editor of Employer Link. Today we'll be discussing a topic that our attorneys have been warning employers about for several years now, and that has to do with the risky business of misclassifying independent contractors. This has now become an even bigger risk for employers with the passage of the Affordable Care Act, also commonly known as health care reform. Under the new law, the financial consequences of misclassifying independent contractors, whether it is intentional or not, are significantly greater, with penalties that could potentially cripple some businesses. Our panel today will take a comprehensive look at all the issues and risks that come into play when misclassifying independent contractors and what practical steps you can take for corrective action now. But before we get started, I want to first go over a few housekeeping items. This program has been approved for 1 hour of general recertification credit through the HR Certification Institute. For those who pre-registered for HRCI credit, we will be sending a follow-up email in the next day or so with program details about today's webinar. Second, on your screen just below the slide presentation area, you should see a tab called Supporting Material. That will allow you to download a PDF version of today's presentation materials. If for some reason that does not work, you can also download these materials from our webinar resource page at employerlink.com/webinar. Next to that tab, you should see another tab called Ask a Question, which you can use to submit questions electronically during the presentation. If time permits, our presenters will address some of those questions before the end of this hour, but whether or not we're able to get to any of those questions during the broadcast itself, we will be posting answers to many of the questions on the webinar resource page sometime next week. Now, if you want to submit a question, please keep in mind that we are not able to answer case-specific questions in this forum. For those questions, we recommend that you consult your legal counsel about the unique issues in your specific situation. Now let's meet our presenters today. You are likely already familiar with our first presenter, Charlie Plumb. Charlie is a frequent speaker and author on workplace issues, not only for our publications and events, but also for many local, state, and national organizations. He represents employers in all phases of employment law and labor relations, and currently serves as leader of McAfee & Taft's Labor and Employment Group. Also joining us is Brandon Long, an experienced employee benefits attorney with McAfee & Taft. He represents a broad range of clients regarding health and welfare plans, retirement plans, and executive compensation. Since the passage of health care reform, he has counseled numerous clients on navigating the many deadlines, provisions, and various cost considerations associated with the law's implementation. Brandon frequently writes and speaks on employee benefits issues, including as a guest legal columnist for local media and a contributing author to various professional publications. Our third presenter is McAfee & Taft tax attorney Keith Peters, who represents clients in complex tax, business planning, and estate planning matters. He has successfully represented taxpayers in appeals to the IRS, the Oklahoma Tax Commission, the U.S. Tax Court, and the federal and state courts. He also is an author for both local media and professional publication, and a frequent speaker on various tax topics. So with those introductions, we'll turn to today's topic. Thank you, gentlemen, for joining us today to present this webinar. Charlie, I'll start with you. Is this something that most employers are really thinking about, or is it flying under the radar?
Well, it's a little bit of both, Brad. We've been talking to employers in the past about the dangers of misclassifying some of their workers as independent contractors rather than employees. I guess how it's under the radar now is, although we've been talking about this, the enforcement and the potential liability has really been spiking here, and we expect it to spike even more substantially in 2013. The other game changers really are that the problems with misclassifying some of your workers as independent contractors and later having them determined to be or held to be employees, the range of liability and problems have expanded. There's a reason we've asked Brandon excuse me, Brandon and Keith to take part, because we're not just dealing with kind of pure HR issues alone when we talk about misclassification as independent contractors. We're also dealing with tax problems and pitfalls, as well as some very substantial employee benefits issues, and that's why we think that Keith and Brandon can add a lot to today's discussion. So what we want to really visit with and cover in the course of our presentation today is what are the problems out there, what's happening from an enforcement standpoint from the various agencies that we're going to be dealing with. And you're going to find out pretty quickly the number of agencies that are involved in enforcement has really jumped substantially. We'll talk about identifying potential problems and liability, and then finish up with some real-world suggestions on steps employers can take to reduce the risk and liability. As a starting point, let's talk about why, when we're out there working with employers, we see companies trying to use individuals to perform worker skills and classifying them as independent contractors rather than employees. None of these are really that surprising, but these are the reasons or motivations employers have folks classified that are doing work for them as independent contractors. They may need some sort of specialized skills that they don't use routinely but come up periodically, so they don't want to devote a particular individual to that, a full-time position, so they use independent contractors. Employers and companies are using independent contractors or classifying individuals as independent contractors from a staffing and economic flexibility standpoint. Particularly now, as we're working our way out of a very slow economic recovery, what we run into a lot is employers that think their business is on an uptick, but they may not want to commit to a quote, employee, end quote. So the way they stick their toe in the pool, as it were, is they'll hire some individuals and treat them as independent contractors to see if really their business is going to pick up as they hope. One of the advantages of treating somebody who performs work for you as an independent contractor rather than an employee is you get to avoid expenses. You may not have to pay them benefits like health insurance or 401k contributions or bonuses if you take the position they're not your employee, they're an independent contractor. Independent contractors that you use aren't entitled to overtime from you. You also avoid some withholding issues that Keith is going to speak to. You're not liable for unemployment claims when you end a relationship with an independent contractor as opposed to an employee. And you may avoid some training and orientation issues and expenses. So there's a lot of advantages employers see by saying, hey, this person that's working for me, I'm not going to treat them as an employee. I'm going to classify them as an independent contractor. We see a lot of employers using independent contractors or classifying individuals as independent contractors or other employees to shift workers' compensation liability, to say, look, as a non-employee, we're at best secondarily liable for on-the-job injury. They're an independent contractor, not an employee, so they're going to be responsible, or their own employer is going to be responsible for workers' compensation liability. And another development we've seen in the context of use of independent contractor classifications is you'll have employers that classify individuals as independent contractors in order to stay below certain statutory limits. For example, the Family Medical Leave Act only applies to employers with 50 or more employees. We've had instances in which we're talking with an employer or working with an employer, and we're running through our checklist, and one of the things we're asking them is, well, does FMLA apply? And they say, well, no, we only have 35 or 40 employees, so we're below that 50 limit. What we've become conditioned to ask is, well, how many independent contractors do you have? Well, we have 35 independent contractors, and so we need to take a hard look to see if they really are independent contractors or not in order to see if that law applies to them. We turn to the question now of whether an individual is properly classified as an independent contractor or an employee. And the two most common tests, and I'll tell you that different laws have different tests, but the most frequent tests we see that are used when an agency or a court is determining if an individual is an honest-to-God independent contractor or employee is the Fair Labor Standards Economic Realities Test or the IRS 11 fact test. And they both tend to focus on control, the control element the employer has over the individual. And we've got a couple of slides that go over the two tests for purposes of comparison. But the common features are what sort of day-to-day control is the employer or supervisors taking in directing an individual's work. If the higher the level of control or job assignment, the more likely they're really an employee and not an independent contractor. What sort of investment is the individual making? I mean, is that individual who's performing services on your behalf, are they providing their own laptop? Are they providing their own work tools? Those sorts of things. Or are you providing them? If you're providing much of their supplies and the things they need to perform those tasks for you, more likely than not, they're an employee, not an independent contractor. Is there a opportunity for profit or loss? In other words, if I'm an independent contractor, I'm probably being paid or should be paid on a project or task basis, and depending on how efficient I am, I may suffer a profit or loss as an independent contractor. Employees tend to be paid hourly or salary, and they get paid the same regardless of whether they've done the job or bid the job appropriately and economically. Level of skills or initiative, if it is something that a task or responsibility that requires some special skills that you and your workforce normally don't have, and it is specialized or non-routine, that's a better argument that they're an independent contractor rather than an individual. Duration of the relationship. Every now and then we run into instances in which we're talking to an employer trying to decide if an individual is an employee or an independent contractor. One of the first questions we'll ask is, well, how long have they been your independent contractor? And when the answer is, they've been my independent contractor for 3.5 years, that's not a good answer, all right? That works against you. The longer the duration, the more permanent of the relationship, the more likely they're an employee, not an independent contractor. Let me skip over to the IRS 11 factor test, and that's really, again, you're going to see a lot of common tests you should apply when you're trying to determine if someone is an honest-to-God independent contractor or whether they should be classified as an employee. We've got the instruction. We've talked about that, the instruction or level of control. Did you give them training? If you provided them the same training that you're providing your employees, likely as not they're going to be an employee. How do they handle business expenses? If they're paying their own expenses, then they may be an independent contractor. If you're reimbursing them or assuming those expenses, again, more likely than not, they're treated as an employee. Item 5, an important point. If I'm an independent contractor, you're not the only organization or employer I'm providing those services to. I'm also providing or offering those services to other entities. So if I've been working for you exclusively, let's say for 12 to 18 months by way of example, and I have not been offering my services to any other entity, that again makes the argument that I'm not an independent contractor. I am your employee. How the business pays, that item 6, that's really, is it a flat fee, task driven, or am I being paid by hourly and salary? If I'm being paid hourly or salary, they have an argument that they're an independent contractor. I'm going to skip to item 8, written contracts. If you are using independent contractors or classifying individuals as independent contractors, make sure your agreement with them, whether it's a full-blown contract or maybe just a letter agreement, make sure that agreement and letters recites the fact that it is an independent contractor relationship, not an employee-employer relationship, and make sure you include in that agreement, whether, again, it's a full-blown contract or a letter, the kind of independence and emphasizing the kind of independence that, again, makes your argument better that they're an independent contractor. We've talked about permanency. We've talked about being the aspect of the regular business of the company. One other thing we're running into that happens, and this is a killer, we have employers in some instances that say, well, yes, Brandon here is one of our independent contractors, and he's an IT specialist, and we treat him and classify him as an independent contractor. Well, where did you find Brandon? Well, Brandon was in our IT department for 3 years as an employee. We just transferred him or converted him to an independent contractor. Some of the agencies that Brandon and Keith are going to be talking about, that really gets their antenna up. If you have individuals who are performing services or tasks on your behalf and you're moving them between employee status to independent contractor status or vice versa, that will really get their attention, and they'll tend to challenge you that.
Hey, Charlie, what if you have a written contract and the contract provides, back to number 8, that that Keith is an independent contractor, but in fact all the other factors weigh in favor of them being an employee? How does that play out? Does the contract insulate you or protect you?
Not at all. It's a great question. That putting that statement or those provisions in a contract isn't a get-out-of-jail card. It helps you make the argument, and it's important to put in your contracts or agreements or letter agreements if you're going to take the position that Keith, in this example, Brandon, is an independent contractor, but it's not definitive. We're still going to look at, or the agencies are going to look at, the individual facts. It's a very fact-intensive inquiry, but I like to say if you're going to take the position that someone is an independent contractor, make sure the agreement or letter agreement reflects that. Let's move to misclassification initiatives. Misclassification initiatives, and you're going to hear in a much greater and more gruesome detail this point from Keith when we talk about tax issues. But we do want to make the point as kind of an overview. Part of this ramping up, we think, or the spiking of enforcement liability is active roles and initiatives some of the regulatory agencies are taking. In September of 2011, the United States Department of Labor and the IRS entered into an agreement where they would specifically share information. And Keith's going to speak to that and how that impacts what's happening right now in the real world in terms of enforcement. But just to give you an idea, that initiative alone, for 2013, fiscal year 2013, the IRS and the Department of Labor have devoted 35 full-time employees and $3.8 million for those two agencies to identify and share information when it comes to employers who have misclassified individuals as independent contractors, when in fact under law they should have been treated as an employee. I don't know how many of our listeners and participants have been on the DOL.gov, the website for the Department of Labor, U.S. Department of Labor, but I encourage you to look at that and pay particular attention to the we can help aspect of it. It's a nightmare for employers. It basically is a solicitation by the Department of Labor encouraging individuals to file complaints or charges against employers, and one of their initiatives is to have people identify instances in which they think they are truly employees but are being treated as independent contractors incorrectly. So that's one initiative. We also have collaboration that Keith is going to talk a little bit about between the United States Department of Labor and the various states. And there are memorandums of understanding between our U.S. Department of Labor and state agencies where for the next 3 years, state unemployment agencies are going to be sharing information with the Department of Labor when they identify through the unemployment process someone who should have been classified as an employee, that an employer is treating them as an independent contractor. The state unemployment agencies are going to be funneling that information back to the Department of Labor. You know, one of the times this comes up in the context of HR issues is you have somebody who you've treated and classified as an independent contractor. Their stint with your company ends, and they turn around and file an unemployment claim. And at that point, in the case of Oklahoma, our Oklahoma Employment Security Commission gets involved, and they make a determination of whether, for purposes of unemployment, Brandon, by way of example, was an employee and should be entitled to unemployment, or was an independent contractor and is not entitled to unemployment. Well, what this memorandum of understanding for the next 3 years, the Oklahoma Employment Security Commission, if they find Brandon should have been an employee who was entitled to unemployment benefits, they're going to communicate that finding to the U.S. Department of Labor, and the U.S. Department of Labor may get involved in some other issues. Within Oklahoma itself, we're starting to see a shared database that is being built between not only the Oklahoma Employment Security Commission, our unemployment agency, but also Oklahoma's Workers' Compensation Court and the Oklahoma Tax Commission, where if one of these agencies, as part of their enforcement effort, are involved, make a conclusion that someone was misclassified as an independent contractor and should have been treated as an employee, whether it was from an unemployment standpoint or a workers' compensation standpoint or state tax standpoint, they're going to share that information with the other two state agencies. So again, that's a development we're seeing. That's increasing the chances of enforcement and potential liability. Briefly, keep in mind what happens when an employer does misclassify an individual as an independent contractor. And we're going to get into a lot greater depth with Brandon and Keith. But keep in mind, number one, we have increased liability. We should have been withholding unemployment. We may be liable for workers' compensation injuries. We contend should not be our liability. Obviously, the tax issues, benefits, which Brandon's going to speak about, people claiming that, look, you've treated me as an independent contractor all along, but I have been an employee. I should have been participating in your plans. And then the wage claims for overtime for people that work more than 40 hours per week, but we treated it as an independent contractor, never got paid overtime. Now they're coming back and saying, what about my overtime? That's kind of the overview. Let's turn it over, if we can, to Keith to talk more on a more focused basis. What sort of issues you see, Keith, in terms of enforcement liability and solutions when it comes to tax issues for our employers?
Well, thanks, Charlie. The first point I would make is just that the IRS has made very clear, particularly in certain industries, and we'll talk a little bit later about what some of those industries are. But the IRS believes that it is losing a lot of tax revenue due to workers who are being misclassified and the service's failure to detect where that misclassification is occurring. And so, as Charlie mentioned, they have pledged to increase and step up their enforcement efforts. And part of this, I think, can be seen as a larger effort to reduce the so-called tax gap, the amount that taxpayers should be paying into the federal coffers versus what is actually being paid in. And, that's an area of focus given the sluggish economy and the country's fiscal situation over the last few years, at the federal level and at the state level as well. And so now the IRS has given public notice that they plan to step up their efforts to detect misclassification where it is occurring. Although general information sharing agreements already have existed, at least between the IRS and the state taxing authorities, back in September of 2011, like Charlie mentioned, the IRS unveiled its specific program that it now has for sharing information on worker classification with the Federal Department of Labor, with the state taxing authorities, and with other state agencies. So in addition to the Oklahoma Tax Commission, other agencies like the OESC, the Oklahoma Employment Security Commission, which administers state unemployment insurance, or SUTA, which is relevant to this to proper classification as well. The IRS is communicating with all of those agencies, both at the federal and the state level.
I'm guessing then one practical aspect of this from the tax standpoint is it's going to increase the chances of detection when an employer has, and sometimes it's not purposeful. It may be inadvertent or accidental, or times have changed. But it's going to increase the chances of that being detected.
Sure, absolutely. If these agencies are out there and they're making a concerted effort to try to detect misclassification where it has slipped through the cracks before, absolutely. The likelihood of these issues being detected increases. And, if one agency identifies it, then, you're then very likely going to have that information shared with each of the other agencies, each of which individually have the ability to impose their own plethora of penalties.
Plethora. I was waiting for somebody to use that word, plethora. How about, can you give our listeners, Keith, some examples, obviously not by name, but just some examples you run into in working with an employer when a state or federal agency has shared with another state or federal agency an instance in which they've discovered misclassification? How does that work in the real world?
Well, in one instance, not too far back, we had the OESC. We had a worker who had applied for unemployment benefits, a former worker who had applied for unemployment benefits. This was a worker that the employer had classified as an independent contractor, and so the OESC comes asking questions, saying, "Wait a minute, was this person actually your employee?" And of course, the client wanted a good resolution on that particular issue, but what they were much more concerned about was if they were to lose that individual case, would that then be reported to the Oklahoma Tax Commission and the IRS, who would then want to talk about all of their similarly situated employees going back, who knows how far, and, what could this snowball into. Let's spend a little bit of time going through the particular risks and try to quantify. If you're wrong on your classification, if you're calling somebody an independent contractor who actually is an employee, and if that's a determination that is ultimately made from a tax standpoint, what sort of monetary liability are you looking at? And the first area is the employment tax. As most of you know, the employer has a liability. The federal employment tax is divided into an employer share and an employee share, and so the employer's share generally equals 7.65% of the gross wages that are paid. Out of that 7.65%, 6.2% represents Social Security, and that's applied up to the wage base, which is adjusted for inflation each year. It's just come out that for 2013, that wage base is going to be about $113,000 or so. And so if you have misclassified workers, that represents the amount, that 7.65% represents the amount of the employment tax that you as the employer should have remitted with respect to that worker.
What about the employee's aspect? The employee has some tax liability. Do we get hit with that too if we've misclassified?
That's exactly right. The assessment you're going to get is going to be for the full amount, not only of what the employer should have paid, but what the employer should have withheld from the employee and then remitted over to the government.
And how far back, if you gave the example where you have an employer that's classified a number of people as independent contractors and one gets found to be an employee, how far back can the IRS go to seek some of these liabilities?
It depends a little bit on the facts. The worst example is if you have not filed 1099s. I mean, if you've just paid, whether it's a worker individually or whether it's an entity. Frequently, what you see is a worker who really should be classified as your employee, but instead that worker has set up their own entity, and that entity is the contracting party with you to provide services. Well,
you mean, for example, Brandon Long IT LLC?
Yep, exactly.
Okay.
So I employ Brandon's corporation. Well, I'm not treating that corporation as an employee, but in addition, I'm generally not issuing a 1099 to that corporation because you just generally wouldn't have a requirement to issue a 1099 to an entity like that. And so, you may never have gotten any document on file that started the statute of limitations running. And so, in that scenario, it's going to be a negotiated settlement with the IRS, but they, in theory, could go back an indefinite number of years.
Now, your slide also talks about a couple of penalties and interest. That's in addition to the employment tax that's due and owing. Is that right?
That's right. You've got the employer's share of the employment tax. You've got the employee's share, which is also generally 7.65%, that you should have withheld and paid over. You've got the employee's income tax withholding that you didn't withhold and pay over. And then you've got penalties. And so there are several penalties that may apply. First is the failure to file penalty. So if you have not filed your employment tax returns, your quarterly 941s, the penalty for the failure to file those returns is 5% of the amount that would have been due, reported and due on those returns per month for the number of months that you have gone on without filing. Now, there's a cap. It's up to a cap of 25%. That's the failure to file penalty. Stacking on top of that is the failure to deposit penalty. So this would be for the withholding amounts, failing to make the deposits into the treasury of those funds. That's an additional penalty, and if it's more than just a few days late, that penalty maxes out pretty quickly at 15%. There also is a penalty for failure to file W-2s. That's equal to $100 per W-2 that you fail to file. There's a per year maximum. Obviously, if you're a large employer, this could get to be a large sum. There's a per year maximum for certain small employers of $500,000, and for all other employers of $1.5 million. That's on the penalty side. There's also the interest side. At the federal level, that is a floating rate that changes quarterly.
What is it right now, approximately?
For the fourth quarter of 2012, it's 3%. So fortunately, we're in a fairly low interest rate environment, and it's low right now. But, depending on how long they're looking back, they may be looking to a time period when it wasn't so low. And one other item to mention before we get to the responsible person penalty, you might think that the worker, gosh, why should the employer be liable for all of these employee side taxes? Because you may have had the worker out there filing its own tax returns, paying self-employment tax, which, really represents both the kind of an equivalent to the employer and the employee side of the employment taxes. They may have been making their income tax payments. Why should we as the employer get hit with all of these? Because the Treasury may have collected those amounts. Well, that's a difficult argument because they've got the authority to look at you, not at other taxpayers. And so unless the workers are willing to voluntarily submit affidavits, have some limited level of an audit, the IRS is not going to be willing to count those payments for your benefit. On the responsible person liability, this is the amounts that you're supposed to collect. So the employment taxes and the income tax, those are withholding amounts, and you as the employer hold those in trust and are required to submit them over to the IRS. If you don't do that, if you don't pay those trust fund amounts over, not only can the employer be liable, but certain responsible persons can have individual liability. The controller, the CFO, the CEO, the folks who really are responsible for remitting those trust funds.
Hey, now you've been telling us about federal tax liability. Can you give us just an overview? Is there a component if an Oklahoma employer has misclassified someone as an independent contractor? Is there also an Oklahoma component in terms of penalties and liability?
There is, and these largely mirror the federal issues. There's a state penalty for the failure to withhold. There's interest, and unfortunately in Oklahoma, that's a statutory rate that does not float based on the market, and so it's actually a 15% interest rate. There's also the state unemployment tax, which is required to be paid by the employer on behalf of employees, and there's a federal counterpart to that as well. But you've got that tax amount, and then potentially the responsible person liability, which probably would only, in a misclassification scenario, you probably would only have trust fund liability if it was a pretty egregious case, because the fact is that you haven't actually taken the money from the worker and failed to remit it. You failed to withhold it from the worker in the first place. But it's at least possible.
Well, Keith, you've been a real ray of sunshine and lighthearted bits of information. How about suggesting to our people what sort of good news or what sort of comfort or what sort of actions can they take to reduce their liability risk?
Yeah, I know the picture's been a little bit gloomy. I mean, just kind of what we've gone through, the tax itself can be large, and frequently what we see when these come up is you'll get an assessment where you've got the amount of tax due, and then you've got interest and penalties that may match the amount of the tax or even be 2 to 3 times the amount of the tax that's due. So it can be a staggering amount, but the IRS recognizes that, and they want to collect the proper tax. They want the reporting to be done right, but they're not, I mean, they don't want to go out and just devastate businesses. And they recognize that it's oftentimes difficult to tell.
Is this your pitch that the IRS is actually a bunch of lighthearted, good people?
Sure, absolutely.
Okay.
The most efficient, most fun to deal with, all of those things.
Okay.
No, but they
like tax lawyers almost.
Absolutely, that's absolutely right. No, they've got a slew of relief provisions that fortunately ameliorate some of the level of the taxes and penalties due that we've talked about here. The first is the SS8 determination. This one is a little bit less common. It's actually initiated by the worker. And so where this most often comes up is the worker's upset at having to pay their own taxes, and they approach the service and say, I want an SS8 determination, hoping that the service will say, well, okay, you're really an employee. Of course, the risk to the business is more so than just that person. If they make that determination for one person, they're very likely then going to say, okay, let's talk now about all your other workers who are similarly situated and how have you been classifying them. So that one is really more relief for the worker rather than the business. But the rest of these, starting with the Section 530 relief, can be very, very beneficial to the business. Under Section 530, rather than the laundry list of 11 factors, you can limit, and this can be applicable in an agency proceeding before the IRS or in the courts, you can limit them from looking at all of those factors and having to provide evidence on all of those factors, and instead have them look at fewer of the factors. And so if you had a reasonable basis for treating the worker as an independent contractor, there's some judicial guidance or something like that, or agency guidance. If you're being consistent in how you're classifying similar workers, and most importantly, if you're filing 1099s, then that helps tremendously and qualifies you for this kind of relief. Section 3509, and this really comes up when you've already been approached by the IRS, this can just really reduce what you end up owing. If you qualify for 3509, then the income tax withholding you have to pay is only 1.5% of the wages paid. If you qualify, then the employer side of the Social Security tax is limited to 20% of the amount that otherwise would be due. And so if you can meet the substantive requirements under 3509, this one can be really valuable. The classification settlement program, this one is instigated by the IRS when you're under audit, and it's basically a way to reach a settlement. And the level of relief here depends on your facts, but you can limit them to looking at only 1 year rather than going back a number of years, and you can end up with a settlement that's equal to your employment tax liability for just that 1 year, or even just a fraction of that 1 year.
What if you end up on the wrong end of one of these determinations? Is there any mechanism? You mentioned, Keith, about how large these amounts can be. Is there any mechanism? You've kept liability as low as possible, but what about paying over time? Is there anything? Is that an option?
Yeah, you get to collection on that, and that is an option. Although that is entirely financial based. I mean, the only way they're going to let you pay it out is if you can prove to them that we don't have the equity in our assets to borrow against or to liquidate, and so there's just no way we can pay this now. Then they'll work with you. The last provision there is the voluntary classification settlement program, or VCSP. That's where you have not been approached yet by the IRS, but instead you realize, oops, we've got a major problem here. We've been doing this wrong. There is the ability to go approach them under this program and to self-report. And the benefit of doing that is that you can typically get them to limit what the penalties and taxes that they're going to impose against you to just 1 year, rather than having them look back. And they give some reductions in computing those amounts as well.
Well, thank you, Keith. Brandon, in terms of fun and lighthearted news, Keith's going to be hard to beat. What can you tell us about liability and risk when it comes to employee benefit plans?
Well, for years, when folks looked at their independent contractors and they would call and ask about independent contractor agreements and how they're structuring their workforce, benefits was kind of an afterthought. They were more focused on HR issues, payroll tax issues, the issues that you guys have kind of been talking about today. But healthcare reform, and really, frankly, the changes that are just going on a kind of an ongoing basis that are being made and being looked at in the benefits arena have created some new risks and some pretty serious issues that people need to focus on. Benefits is right now incredibly hot and crazy, which you would never describe benefits that way typically. But like this morning, for example, I kind of the message board for nerds that I read talks about how the fiscal cliff discussions involve discussions about putting caps on the amount that people can receive under a medical plan on a tax-free basis. And so there are a lot of things, a lot of changes coming down the pike, even right now. So in our seminars before, and everybody's been seeing a lot of talk in the media about the so-called player pay penalty. And this is a penalty that kicks in 2014, and really what it says is if you're an applicable large employer and you fail to offer your full-time employees health coverage, you can get hit with a $2,000 per employee tax. And so a lot of folks say, well, am I an applicable large employer? On our slide there, one of the bullets, applicable large employer, that is defined generally as an employer with 50 full-time equivalents or more. So some people here...
Full-time employee.
Nope, it's equivalent. So it could be, you could have 40 full-time employees and you could still be a applicable large employer if your part-time employees in the calculation that you need to run kick you over the 50. And where this might come up with independent contractors would be if you had 40 full-time employees as an example and you had a bunch of independent contractors who are really employees. If they were later reclassified, this could easily kick you over the 50 mark and make you an applicable large employer.
So I could be using a lot of independent contractors, classifying them incorrectly, and I don't even, if I've misclassified them, I don't realize that I am a large employer for the purpose of the player pay.
Right. You don't even think about having to comply or worry about health care reform. And really the player pay penalty, and this is where it gets kind of important, and if to the extent you're asleep or on the verge of sleeping, this is, and you listen to nothing else that I say, this is what I would focus on right here. So the penalty is calculated based on, it's $2,000 per full-time employee, generally. And so where we see this and what we're really concerned about and what we've been talking to folks about is, let's say you had 10,000 employees and you offered 9,999 of them health coverage, great health coverage, expensive health coverage. But you have one person, extreme example, but you have one person who's you've got classified as an independent contractor who is in fact an employee. The IRS audits you and they reclassify that person as an employee. Theoretically, and again we're kind of talking Chicken Little stuff, your entire population, even the 9,999 employees that you're offering health coverage to, would go into the calculation of your $2,000 per employee tax. So we're talking significant risk here. Now, just 3 weeks ago, I went to a conference where the head guy of the IRS who's involved in drafting the regs on player pay was speaking, and he indicated that they're looking behind the scenes. This is, may not happen, but he indicated they're talking about maybe making the penalty a little more proportional rather than being so drastic like what I described. But as of right now, this is kind of what we need to be thinking about. And after our last seminar, some guidance came out on how you determine who your full-time employees are. And this is kind of another point, a little bit off topic, not really, but another thing you really need to be doing right now, let me say that again, something you need to be doing right now is in 2013, that is generally what is the measure, the period, kind of a look-back period that the IRS allows you to use, the government allows you to look at 2013 and say, okay, based on my employee population in 2013 and the hours they work in 2013, who are my full-time employees in 2014? So you don't want to wait until December of next year to identify and start tracking the folks that are working 30 or more hours, because a full-time employee and forgive me if I didn't say it at the beginning, a full-time employee is defined as an employee who works on average 30 or more hours a week. So you need to be looking at your hours in 2013 of your employees to make sure you've got them classified properly in 2014 when this crazy penalty kicks in. And likewise, you need to make sure that you've got your independent contractors classified properly as either independent contractors or employees, because if you've got them classified as an independent contractor, you may not track them like you would track your employee population. So it again is very important to take a good, hard, honest look at the folks that you've got classified as independent contractors and make sure you're looking at their hours properly in 2013 as you do all your other employees for 2014. Another issue that I think, and again in my nerdy way that I kind of get crazy about, is this control group issue. If you have this, back to what I was just saying, if you had let's say you owned a business, a bank, or let's say you worked for a bank, you're the HR person at a bank, and you have 100 employees, and you give all 100 of them great coverage. But let's say that the owners of the bank also own 10 restaurants, and those restaurants have full-time employees, or they have independent contractors who are misclassified, and you fail to offer any one of those employees in the restaurants health coverage in 2014, theoretically, all of the employees, including the 100 at the bank that you're offering coverage to, go into the $2,000 per employee calculation of the tax. So it's pretty significant. Now, shifting gears, we've talked about health plans and the health care reform stuff. Let's shift a little bit into qualified retirement plans, and let's just think about, for example, a 401k plan. So let's say Charlie is an independent contractor, and Charlie works for McAfee and Taft. And we're treating him as an independent contractor, so we don't want to worry about payroll taxes, and we don't want to give him benefits. Well, let's say 5 years from now, 5 years after Charlie is first classified as a contractor, let's say he is retroactively reclassified because of an audit as an employee. Well, for 5 years, he's not.
Let me say.
Yeah.
When you say an audit, you mean by
the IRS or anybody? Yeah.
Okay.
So let's say he's reclassified by the IRS or any government agency, but let's just say the IRS as an employee. Well, for 5 years, Charlie has not been given the opportunity to make deferrals into the 401k plan. He's not been given an employer contribution for McAfee and Taft for the 5-year period. And so the question becomes, is he entitled to 5 years' worth of contributions plus earnings?
This law firm is treating me horribly, Brandon.
Well, you deserve it, Charlie. So the question is he entitled to all these back benefits with interest? And the answer is no, as long as your plan document has what is called the Microsoft language. And Microsoft, and not get into that, but there's a series of cases involving Microsoft where they had misclassified some folks. And the key takeaway here on this point is you need to look at your plan document, your 401k plan document, for example, or your pension plan document, and look at how it defines an employee. And it should say something like this. An employee is a common law employee, and it could be a leased employee, but it should have this language that says, if a person who is classified as an independent contractor is later reclassified as an employee, that person is not entitled to retroactive benefits, but would only be classified as an employee and thereby only eligible for benefits on a prospective basis. A lot of plans have this language, some don't. If you don't have it, you should add it.
And Brandon, where is that most likely? If after this webinar, if I'm going to go look at my plan document, where would I look for that?
Look at the definition sections of your plan. Most people, I see it in like Article 2 of your plan document.
Okay.
So it would be in your definitions, just in alphabetical order. There should be a category that says employee. Make sure that you've got the language. Not the end of the world if you don't. You just need to add it. The other kind of flip side of this analysis could be a scenario where we let Charlie participate in the 401k plan, even though he really is an independent contractor, because Charlie's kind of a pain, and he complains and throws a fit, and so we let Charlie, who really is an independent contractor, participate in the McAfee and Taft 401k plan. Well, Charlie is not an employee, So it's kind of the reverse. And because he's not an employee, he is not eligible for the plan, technically. And so technically what you have is McAfee and Taft, an employer and its employees participating, and you have a non-employee participating, which typically means is a qualification problem. It can disqualify your retirement plan. Again, for those of you that have this problem, don't freak out. You can fix it. But you need to be thinking about that. You should not let your independent contractors participate in your 401k plan unless you're treating your plan properly. Like, for example, the plan provisions allow it, and you're treating it as a multiple employer plan or something along those lines.
You know, one of the things that's interesting now is we know from talking with enforcement agencies or reading some of the material out there, we now have some idea of who these various agencies, whether it's the Department of Labor, the IRS, whether it's a state agency or a federal agency, they've identified for us what particular employers they're targeting. And you see up on our PowerPoint right there, construction companies, janitorial services, home health care, employers involved in child care, if you're in the transportation and warehousing industry, meat and poultry processing, and really a lot of professional and personal service industries. If you go to the websites by the Department of Labor or by some of the state taxing and federal taxing agencies, these are what they're telling us, the industries and the employers they're targeting. Let me turn first to Keith. Keith, what have you seen in terms of enforcement when it comes to tax issues? Are these some of the same companies and employers are being targeted, or are there others that are hot topics right now for purpose of the taxing agencies?
These are some of the common industries, although I think, this is really kind of on a national level. What we see regionally from the federal government and at the state government level in Oklahoma is the oil and gas industry as well, is one that is often targeted.
One of the things I think that agencies use to develop enforcement targets, and oil and gas industry is a good example, when they find or they hear they have a series of complaints of individuals being misclassified as independent contractors, and in fact they're employees, that gets you on their list. And I don't think it's any secret that the Department of Labor and some of the taxing agencies have targeted our oil and gas industry here. Brandon, your experience, who's under the microscope when it comes to benefits issues?
Well, I think the industries you've identified cover, and oil and gas for sure, cover it. And the things that they're going to look at, once they go through their analysis of whether they think your population is that are classified as independent contractors or employees, if they determine you've made an error, then they're going to look at your plan document and see if you owe a bunch of back benefits, like your 401k plan. And they're going to want to see if you owe, again, in my example back to Charlie, if you had 5 years' worth of benefit contributions that are due for Charlie. So I think you've identified the industries. My recommendation, and it's a little off track here, would be, and maybe this ties into our next slide as I'm looking, but I would do kind of a self-audit analysis, put together a checklist that you can kind of go through and say, honestly, with your consultants, attorneys, whatever, how are we treating people, and are we treating them properly?
Well, let's go to our suggestion about being proactive, and I hope our message is pretty clear. We've got active enforcement agencies at both the federal and state level that are committed to taking a hard look at whether we are properly classifying individuals as independent contractors or whether they are in fact employees. I think a common message you've heard from all three of us is if you end up on the wrong side of that determination, the liability is substantial. So, Brandon, you talked about a self-audit. From an HR standpoint, I'm going to want to ask you guys to follow up more particularly on benefits and tax records. But, the self-audit, for one thing, as a starting point, find out right at the get-go how many independent contractors do you have, and find out where they show up. Are they in particular areas, particular departments, particular skills? But get your arms around how many independent contractors, how many individuals are you treating as independent contractors, and where do they most frequently occur? That will give you a really good idea of the potential scope of liability and where that self-audit occurs. Look at job descriptions, look at job classifications. This self-audit also means talking with our payroll and our compensation departments to see what sort of practices we're following when it comes to employees versus independent contractors, what we're doing in the way of timekeeping or payroll records and payment records, the basis for compensating our independent contractors as opposed to our employees. The self-audit, look at your workers' compensation history. Have you had some contested claims where individuals have filed for workers' compensation benefits saying, I'm not an independent contractor, I'm really an employee, and how did that come out? Sometimes that's a good red flag. Same thing with unemployment claims. Unemployment claims, the examples we've given, have you had some instances in the past where you've ceased using a particular independent contractor and they've filed for unemployment? How did that happen? Again, that's sometimes these workers' compensation claims and the unemployment claims, that's a wake-up call that we have some problems. Look for trends. Look for how and where we're using independent contractors, and look at our record retention. Keith talked about going back multiple years for potential liability. Let's make sure if we're going to have to defend our classification for independent contractors that we're retaining our payment records and our classification records far enough back that we can really go to bat for ourselves. Brandon, more particularly when it comes to a self-audit on classification or potential misclassification of independent contractors, you mentioned the benefit plans, looking at those. What else would you recommend our listeners include in their checklist of that self-audit from a benefit standpoint?
Well, the checklist is going to be the same that you went over for your factors, identify the control and how you're paying them and all that stuff that you just went through. I would say, though, that the folks that I talk to, and I suspect those of you listening, you probably know where your dead bodies are buried. I mean, you probably know, as you're sitting here listening, you're probably squirming, thinking, oh, my goodness, what about such and such group of people? And if your instincts tell you that you may have a problem, you may have a problem, and you need to think about it. So I would put together a checklist using the factors that you identified earlier, Charlie, and then just go through that. And the good news is, you guys, is if you have a problem and you've been doing things wrong, which a lot of people do, including, even our law, we're not perfect. Nobody's perfect. You can always fix things, and there's a way to fix it, including this. And so I would just encourage you to be proactive, put together a checklist using the factors Charlie's identified, and then from a benefits perspective, just kind of make sure that you've got your folks classified properly and that they're being covered or not covered in your benefit plans.
One thing I might suggest is, as part of that checklist, when you're looking at benefits issues, identify who are your participants and who are your non-participants, because that may show you where you have a potential problem.
Good.
Keith, to you, again, what additional factors or records or documents would you put in that checklist for that self-audit when it comes to tax issues?
Well, I'll tell you, what we would be looking at from a tax standpoint in doing this self-audit, it's sort of twofold. The first item is, do you have a clear misclassification? Because if we determine that, hey, I know the IRS or one of these agencies has not approached you yet, but by gosh, if they do, you're going to lose. You really don't have the strong argument to support that these folks really are independent contractors. Then, the analysis becomes, well, okay, should we consider self-reporting in order to try to get the benefit of some of these more lenient enforcement provisions? That's number one. Number two, if you truly have a close call, and frequently it is a close call, if you're in that situation, then there are tweaks that can often be made that won't necessarily give you or the worker any heartburn, that will strengthen the argument if it were to come up that these folks really are independent contractors. You can also do some things like making sure that 1099s are being filed in order to set yourself up to qualify for some of these relief provisions if you do end up getting that bad determination. And, so that's all on the self-audit side before you've been approached. If you have been approached, if you've, gotten an assessment from the IRS, then I would say, get in touch with someone to represent you as soon as possible because, once we get to that level, really the earliest in the process that you get someone involved who's going to be proactive in working with that agency, the greater the number of procedural and strategic options that you have for trying to deal with that enforcement. So too often we don't see them until late in the game, and a lot of the options that we would have had are no longer available to us.
Well, thanks, Keith, and thanks, Brandon. I hope we've been helpful in giving everyone a good overview of what you can expect in the coming 12 months in terms of enforcement trends, and identified some potential pitfalls, and ideally also, particularly with our closing on some proactive steps. Like a lot of things in employment, the reactive is always a lot more expensive and a lot more painful. To the extent you can be proactive with these self-audits, now recognizing some of these issues, you're going to be ahead in the game. One thing, we always try to include some added value to our webinars, and this webinar is no exception. So our panel, including Brad, we're going to go ahead and give you our predictions for the National Championship College Championship on January 7th between Notre Dame and Alabama. Brandon, your prediction, not just as to winners, but points as well, scores.
I'm going to say Notre Dame 21, Ohio State 7. Oh, I forgot Ohio State's not eligible, Charlie.
Thanks for the dig.
Alabama 7. Yeah.
Thanks for the dig. 21-7.
Yep, Notre Dame.
Notre Dame. Keith?
Well, as a loyal OU fan, I think out of stubbornness as much as anything else in history, I can never pick the Irish. So I'm going to go with Alabama 21-10.
All right, Brad, your prediction?
I'm going to go with Notre Dame because I don't want Alabama to win, with all due respect to our Alabama listeners. But I'm going to go 15-14.
By whom?
Notre Dame.
Notre Dame. And I'm going to go Notre Dame 17, Alabama 14. Now, here's the bad news. You know, usually when you're just talking over the coffee pot, everybody forgets when you make a bad prediction, but like our other webinars, we'll be archiving this on our website. Please feel free to use it, hopefully productively, if you with anybody that might be able to use this information. And I guess we'll see how close we were on our predictions as well.
All right.
Thanks again for participating.
Before we close, just a few quick reminders. First, you will soon be getting a follow-up survey about this webinar. Please take a few moments to complete that questionnaire. Your feedback helps us improve our events, as well as letting us know what topics and issues are on your minds. Also, there are several questions. We did run short of time, but we will be looking at those questions and posting to the webinar resource page answers to most of those questions, and we will have that up sometime next week. Also, as I mentioned earlier, those who pre-registered for HRCI credit will receive an email in the next day or so with program details about today's webinar for recertification submission. Later this afternoon, a recorded version of this webinar broadcast will be available on our webinar resource page, as well as the downloadable version of the presentation materials is there. You can easily access that resource page from the home page of both EmployerLink.com and McAfeeTaft.com. That will wrap it up for this edition of the EmployerLink webinar series. I want to thank again Charlie, Brandon, and Keith for presenting today's webinar. And on behalf of the law firm of McAfee & Taft, thank you for joining us today, and we want to wish you a very happy and safe holiday season. And we'll see you next year. Thank you.